Good day. My name is Printon Kodumrong, and this is my thesis project based on the recognition and enforcement of foreign arbitral awards. This matter is in regards to international arbitration, which is an alternative means of dispute resolution, where there is a chosen tribunal of arbitrators instead of judges, which means that there is more independence to choose the forum instead of just being a domestic jurisdiction. One of the key differences between arbitration and litigation is that after an arbitral award, which is basically the decision of the case, is made, it must then be enforced in the relevant country. And this enforcement is what I will be discussing today. Before then, I would like to talk a bit more about the key principles of arbitration. Now, the arbitration that I'm referring to today usually is between two or more entities from different countries. And today I want to focus on public and private entities, in which case it's investment arbitration. The key principles of arbitration is that of fairness, meaning that no party must be precluded from any kind of procedural advantage, and the validity of the arbitration agreement, meaning that the decision or the sort of document that says that they are allowed to go to arbitration must be clear and must be fitting with the obligations and with the criteria specified. Now, the big factor of international arbitration is its finality, meaning that unlike arbitration, unlike litigation, it is not subject to any kind of appeal. Another thing that is important is the choice of jurisdiction, which is the law that governs the proceedings and the interpretation of the award. Now, the enforcement can be made in any relevant state. However, another means of preventing the award from having effect is to set it aside, meaning essentially to invalidate the award. And this can only be done under the common understanding of international arbitration community that can only be done in the place where the arbitral award is made. Now, the validity of the arbitration agreement and the proceedings are very important because it shows that another key aspect of arbitration is its procedural fairness. Some of these principles are then enshrined in what's called the New York Convention, or the Convention on the Enforcement and Recognition of Foreign Arbitral Awards, of which Thailand is a party to. Now, this convention shows that there are specific grounds in which an arbitral award cannot be enforced, which includes the incapacity of one of the parties to enter into an arbitration agreement or to the proceedings. There's also the idea of the procedural invalidity, where the idea is that if there is an improper number of arbitrators, according to the agreement of the parties, then it is not arbitral, or in which case it is not arbitrable under the national law, which all of these cases means that they cannot be enforced. Now, another key concern, and one that I would like to focus on today, is that of the award itself being contrary to public policy, which is something that Thailand as a country has been very vehement in using as a grounds. And this is because public policy essentially means that it has become a catch-all term for disencumbering themselves from responsibility, because public policy in itself does not have a precise definition under sort of international arbitration practice. And the most used definition is that a violation of public policy must violate essentially the most basic notions of morality and justice, as stated by Judge Joseph Smith in 1974. So this essentially is the sort of grounds under the New York Convention of not enforcing an award. Now, since Thailand is a party to the New York Convention, as is the case with most countries, that is why this can be used. Now, referring to Thailand specifically, they also have the Thai Arbitration Act, which is almost a verbatim adoption of the New York Convention. However, it has more emphasis on Thailand being used as the default when it comes to an absence of an agreement between the parties, and particularly in the idea of stating, instead of saying it is a violation of public policy, it is public order. Now, public order under Thai law is something that in my opinion, has been used to a very extreme extent, to the point where it has become a way of freeing themselves from responsibility. And this can be shown in the following cases. The cases that I present are the Walter Bao case, as well as the Hopewell case. Now, both of these cases involve a construction contract between Thai authorities and foreign companies. Now, they both have a promise by the Thai authorities to finance the projects, and there is an agreement to approve things that would facilitate the successful operation of these highway tolls and the construction of highways. Now, both of these cases ended with the Thai authorities having to pay a certain amount of compensation towards the companies, as decided by the arbitral tribunal. Now, the awards resulted in this case still means that Thailand refused to comply with their obligations under the contract because they refused to enforce. In terms of the Walter Bao case, they refused to enforce due to the fact that they believed that Walter Bao was not a party to the concession contract, the contract between the two that allowed for Walter Bao to effectively profit from their sort of mission, basically. So even though the issue was already resolved in the decision, Thailand still refused to acknowledge this and therefore pushed further for them to not be enforceable, as if they weren't a party to the concession contract, then they do not have the right to proceed to arbitration. The second grounds that they used was that under sovereign immunity, and they said that Thailand was entitled to withhold the approval for tollway hikes because it was a matter of public order, since the sort of approval of a tollway hike would increase the prices of the tollway. And since it was at a time where Thailand had gone through a financial crisis, they believed that it was their responsibility as the Thai authorities to promote the economic well-being of the countries, which is something that should not be under the definition and does not meet the threshold of public policy, in my opinion. In terms of the Hopewell case, this has more concrete reasoning, which is that the Hopewell could not bring their issue to arbitration due to the fact that it had lapsed the prescription period, since the prescription period is 5 years, and from the date in which the issue had occurred. But in the Hopewell case, this prescription period had already lapsed by the time that they brought action. So therefore, that they were not entitled to bring the case to arbitration in the first place. And Thailand brought this issue to the administrative court. And in 2014, the administrative court decided to set aside the award on these grounds, since in the Hopewell case, the jurisdiction that was used was under the Thai Arbitration Institute rules, and was also, this was actually kept rather secret, but the overall decision was made to set aside the award. Now, the main issues that I'd like to talk about is, firstly, the broad definition of public policy. I believe that Thailand must aim for a narrower definition of public policy, as just an error in law, in which case in the Walter Bao case, is essentially just that. And also in the Hopewell case, it is thought to be basically about the idea of prescription, since prescription is an issue that resolves in sort of not following the law of that country. It shouldn't be a matter of public policy at all. It should be an alternative grounds under the New York Convention as well as the Thai Arbitration Act. So essentially, there is an incorrect application, as it is not a matter of public policy in the case of Hopewell. The second issue I'd like to talk about is the fact that they do not respect the finality of the award, as they try to set aside it in Thailand, and should not be a subject to appeal as it was. So to briefly conclude, if Thailand wishes to become a hub of arbitration, it must therefore first adjust its mindset on when to refuse enforcement, so that the efficacy of international arbitration in Thailand is protected.